Okay, this week we're covering Chapter 10, which is our homicide chapter. In addition, in our blue book, you're going to be covering crimes against persons, specifically homicide, assault, and kidnapping under Chapter 565. I've provided a link so that you can look at the statutes on your computer or read them through the blue book. So I'm going to cover our vocabulary. Just to be specific, that homicide is the killing of one human by another. We'll cover it as far as justifiable, excusable, and felonious as we get through the lecture. Our born alive requirement: to be able to charge homicide, a baby must be born alive. Feticide is the murder of an unborn child. Murder, unlawful homicide with malice aforethought. Not all homicides are going to be unlawful. Transferred intent, a doctrine used when the intention to harm one individual inadvertently causes a second person to be hurt. Premeditation, mental determination to unlawful kill another person after planning or reflection. So felony murder, all states have this statute. It's different as far as what each state says it is, but basically if you're committing a felony crime and a person dies of that, then depending on the circumstances, you can be charged with that murder. Manslaughter, criminal homicides other than murder. Perfect self-defense, homicide in which the killer not only subjectively believes that his or her conduct was necessary and reasonable, but by objective standards, which objective means, population as a whole, it was lawful and complied with the requirements of the law. Imperfect, homicide which the killer subjectively but unreasonably believes that his or her conduct was necessary. So subjective means you as an individual. It may be unlawful if the killing was done with excessive or unnecessary force, an unnecessary killing in self-defense, in defense of another, or to prevent or terminate a felony of violence. Could be an imperfect defense. Euthanasia, killing of a terminally sick or injured individual. Assisting suicide, the act of furnishing the means of a suicide pursuant to state statutes. And then corpus delicti, Latin term meaning the body or substance of the crime. It doesn't actually mean a physical body, it just means proof that the crime's been committed. And then actus reus, the criminal act, and then mens rea, the criminal intent or state of mind. I want to review just a little bit on our culpable mental states. So remember, acts purposely, conscious object or desire to engage in that conduct, knowingly aware that his or her conduct is practically certain to cause the result, reckless, is a gross deviation from the standard of care which a reasonable person would exercise. And then criminal negligence, fail to be aware of substantial and unjustifiable risk. And I provided the link right here so that you can go read the entire one. You need to be very familiar with your culpable mental states because most statutes are going to start talking about knowingly, purposely, recklessly, criminal negligence unless it's a strict liability crime. So, U.S. Supreme Court has never created or announced a doctrine requiring proof of mens rea in all crimes. When we cover felony murder, I want you to think about that one. So, elements must be proven beyond a reasonable doubt to convict someone of a criminal offense, although exceptions exist. So, proof beyond a reasonable doubt means that it's not enough to prove that it's probable that an element of the crime is true. The proof must be such that a reasonable person would agree that the elements of a crime are present. So, again, elements of a true crime. We have the actual act or failure to act, mental elements or mens rea, the harm element, what actually happened, killing, injury, damage, loss, and then the cause element, the harm was done was a natural and probable result of the wrongful act. So when we look at death, we're going to look at the manner in which it was done. So is it natural causes, homicide, suicide, accident, or undetermined? We don't know. So let's say we find a skeleton with no visible trauma. All we know is that, this was a person, but we do not know how they died. So homicide in general, the death of any person caused by another person. So justifiable homicides would be state execution, police use of force, and then self-defense. Excusable homicides could be self-defense that, maybe aren't perfect, but a person believed they were, and that the courts would look at it as excusable. Criminal, there's where we fall into your murder, manslaughter statutes. So homicides are either justifiable or excusable or crimes. The degree of the homicide depends on the circumstances surrounding it. So in most jurisdictions we have murder, manslaughter, and then negligent homicide. And this will be worded depending on where you live and what your state statutes are. So corpus delicti means the body or substance of the crime must be proved. So again, do we have to prove that a person died? We can prove these cases even if their body is not there. That's something that your prosecution team will look at, of how can we show that this person was alive and now that they're not. So confessions are substantial evidence, but in some circumstances may be dismissed in court due to a mistake. So when you're speaking with somebody and you're trying to elicit that confession, you have to think about how you're doing that. Does this person have some mental issues? Is there coercion? Are you withholding sleep, food, bathroom breaks, something to drink? Is someone else trying to accept the blame? Child case or reliable evidence other than the confessions may be able to use as far as that goes. But confessions by themselves may not be enough to actually get to where you need to be as far as a criminal conviction. Again, corpus delicti requirement, no body cases, hard for prosecute, even with the evidence that you have. You're going to have circumstantial evidence, evidence with trial which is not directly from an eyewitness or participant and requires some reasoning to prove a fact. So it's not direct evidence, but the evidence is going to, provide the information where a reasonable judge or jury could have enough to go ahead and say that, this person actually committed the crime. One of the more interesting sites that it talks about in your text is NamUs. Basically, it's a site sponsored by the federal government looking to provide help in missing, unidentified, and unclaimed persons cases. So let's say a person is found deceased and they would help in identifying this person. There's quite a few other resources that are available. I'll let you go to the site and explore. So equivocal deaths, we're looking at this as we just don't know exactly what happened. SIDS, or sudden infant death syndrome, would be a good example of this, in that you have a very young child, so probably under a year, that just passes away for no underlying condition that we know about. And even during the autopsy, the doctor cannot find anything. Toxicology doesn't reveal anything. This would be that equivocal death, in that it's just questionable. We don't know what caused it. So, proof that the victim was alive. Homicide requires that the victim died. So alive in most jurisdictions means the person has a heartbeat and is breathing, even if on life support. Prosecution has the burden showing that the victim was alive at the time of the unlawful act, and one cannot kill a person already dead. Usually that's another crime as far as tampering with a corpse or something like that. So the fact that the victim was about to die from another cause does not mean the victim was not alive. So we've got a person that has a fatal injury, but at the same time they still have a heartbeat, they are still breathing, and then somebody comes along and causes another fatal injury that immediately stops life. That would be the homicide right there. Depending on what state, if the brain death occurs, then a homicide can be charged. In majority of homicide cases, cause of death must be determined to achieve. So what caused this? It's not the manner of death as far as homicide, suicide, natural causes, so on. It's the cause of death. Was it a gunshot, stabbing? What have we got going on as far as proving that? So each state, since its own sovereign government, decides laws. So Missouri, I've provided when life begins. We actually have that statute, and when life ends. So when we look at the definition for Missouri as far as death, the legal definition, the occurrence of human death should be determined in accordance with the usual and customary standards of medical practice, providing that the death shall not be determined to have occurred unless the following minimal conditions have been met. Respiration and circulation are not artificially maintained. There is an irreversible cessation of spontaneous respiration and circulation, or, and that's important right here, or when respiration or circulation are artificially maintained and there is a total and irreversible cessation of all brain function, including the brainstem, and that such determination is made by a licensed physician. So this is our definition of legal death as far as the state of Missouri goes. And these links are both going to be in your PDF file that I'll attach so that you can go and read them both. So again, born alive, be able to discharge homicide, newborn baby, prove that the child was living at the time. So causation requirement, or cause and fact, means that the result would not have happened but for the conduct in question. So A shoots B, wounding him. To escape, B jumps in the river and drowns. A's actions are the cause and fact of B's death, even though B drowned. When there is a substantial time gap between an injury and the victim's death, the defense may contest, this was the actual cause of what happened in that case. So proximate cause or legal cause means the defendant can be held responsible for the death even though it occurred in a different manner than intended. So if offender breaks into a house with an axe and the homeowner dies of a heart attack or a stroke or something like that, something that caused due to stress of the actual break-in, then that could be considered that proximate or legal cause. Intervening causes, independent intervening cause can break the chain. A stabs B, causing injury that will be fatal. And just like we gave an example a while ago, C comes across B, robs him, and shoots him. So C actually caused the death. Even though A, the injury would have been fatal, this is actually probably going to be that first degree assault where this will be the homicide or murder. So subsequent causes are foreseeable in response to the criminal acts. So A stabs B, inflicting a serious wound. C, a doctor gives B too much anesthetic and B dies. So C's negligence, if foreseeable, is not an intervening cause. So murder, while the act resulting in a death must be voluntary, the mental state, so there's our mens rea that we were talking about just a minute ago, has to be there. So we have to have some premeditation, so purposely, knowingly. Second degree murder, intending to cause the death but without planning. This could be where we're talking recklessly or criminal negligence. Even where conduct is not accompanied by the intent to kill or cause serious bodily injury, extreme recklessness can show that cool disregard. And we start looking at that and reading what our suspect did, and we're going to compare back and forth as far as what actual crime we're going to charge. Again, here's our felony murder rule, where somebody dies as a result of a felony even though there was no intent. So this is where our strict liability crimes come into play. First degree murder typically involves malice aforethought, so some type of premeditation and deliberation, and we're thinking about why we did this. Now, malice aforethought, there's no specific time. It can be a very short time. Premeditation, again, so active planning prior to killing, and does not have to be well in advance. Somebody is in a bar, somebody makes them upset, they walk out to their car, they get a weapon and walk back in and kill them. Even though there might only be a few minutes in between the actual, confrontation and then the killing, that is still enough time to be looking at premeditation. So a deadly weapon, committing a crime by use of a deadly weapon, such as assault with a deadly weapon, is commonly a separate and more serious crime, but it can be used to show intent. If somebody takes the time to get a weapon and then come back, or comes with a weapon, that definitely is showing intent. Now, when we look at Missouri statutes, we can look at armed criminal action. Basically, any person who commits any felony under the laws of the state by, with, or through the use, assistance, or aid of a dangerous instrument or deadly weapon is guilty of the crime of armed criminal action. So we have a separate crime in that the person used a weapon in that crime as far as our state goes. And like we spoke about, the use of that weapon creates an inference of the user's intent as far as malice. So presumption may be read by proving that the person using the deadly weapon did not intend death to result, as where a gun was shot in the air only intending to frighten the victim. So when we look at weapons, basically anything in the right circumstances could be used as a weapon. So transfer intent, we mentioned this briefly when we started talking through our vocabulary. Doctrine rests on a sensible foundation that where one has demonstrated the intent to take another person's life, it should not matter whose life is taken. So the example is that you're intending to kill one individual, you shoot at that individual, but your aim is not that great, and you kill the person beside them. You may not even have known the person beside them, but we're going to say the intent was there to kill them because you intended to kill someone initially. So just like we talked about here just a second ago, A shoots B, intending to kill B, but misses and hits C. A is guilty of intent to kill. So in most jurisdictions, it doesn't matter if both the intended victim and the unintended victim die. Transfer intent is not needed where A kills a person he thinks is B, but is in fact C. So basically, if you're trying to kill somebody, even if you kill the wrong person, we're going to still say that, that murder happened. So second degree murder can be called different things: depraved heart murder, serious bodily harm. Again, this is going to depend on the state that you live in. Actions can constitute murder in the second degree even without intent to cause death. So the actor intended to cause serious bodily harm such that death would result. So we look at this, we're looking at our culpable mental state as reckless. So depraved heart murder typically involves extreme indifference to the value of human life. You just didn't care. So when we look at our state statute, the statute itself isn't exactly that long. So number 1, knowingly causes the death of another person, or with the purpose of causing serious physical injury to another person causes the death. So you were planning on hurting somebody through an assault, yet you cause their death. That's going to fall under the second degree. Commits or attempts to commit any felony. So this is our felony murder statute right here, if you were looking at Missouri. Basically any felony, the perpetration or attempted perpetration of such felony, or in the flight from the perpetration. So let's say our person commits a robbery, they leave at a high rate of speed in a vehicle and accidentally hit a pedestrian. They could be charged with a felony murder based on that they were fleeing the scene of that crime. So as you read our statute and through your blue book, think about, what type of premeditation, or if they even need premeditation as far as our statutes go. Again, felony murder, person dies during the course of different related felony being committed by that person, and each statute is going to be just a little bit different. Felony murder conviction does not require showing of the malice or deliberate intent to kill. It could be a total accident on the person. Like we said, the person fleeing the scene of the robbery did not intend to hit another person with a car, but it happened. It can still be charged as that murder. So manslaughter, divided into voluntary and involuntary. Homicide, many state statutes now have only one crime of manslaughter. Missouri, we're going to look at ours, and we have more than one. So other states have added a vehicular manslaughter charge. Involuntary manslaughter is a death that occurs without intent but as a result of unlawful activity. So voluntary manslaughter, this is our Missouri statute, causes the death of another person under circumstances that would constitute murder in the second degree, except that cause the death under the influence of sudden passion arising from adequate cause. Also, we'll talk about this here in a little bit, but knowingly assists another in the commission of self-murder. So this is assisted suicide right here as far as that statute goes. Involuntary manslaughter, a person commits the offense of involuntary manslaughter if the first degree, if he or she recklessly, there's our culpable mental state, causes the death of another person. Involuntary manslaughter second degree, a person commits the offense of involuntary manslaughter in the second degree if with criminal negligence. So here is our culpable mental state right here, and it's the lowest one as far as culpable mental states go, as far as causing that death. So remember, when we talk about criminal negligence, the person fails to be aware of a substantial and unjustifiable risk that circumstances exist or the result will follow, and such failure constitutes a gross deviation from the standard of care which a reasonable person would exercise in that situation. So they fail to be aware. They should have known that it was going to happen. They should have thought about it beforehand, yet they didn't. So again, the lowest standard that we can have as far as culpable mental states other than a strict liability. Voluntary manslaughter differs from murder charge in that it's not accompanied by premeditation or malice, heat of the moment, or as far as self-defense goes. So heat of passion, all states provide for a lesser charge of murder to involuntary manslaughter or an intentional killing occurs in the heat of passion. So when we look at our statute, which under 565 is going to be sudden passion, so passion directly caused by and arising out of provocation by the victim or other acting with the victim, which passion arises at the time of the offense and is not solely the result of a former provocation. So this is immediate indication of something that's going to cause that person to become so uncontrolled in their emotions that they lash out. So, reading from your text, sufficient provocation naturally and instantly produces in the mind of an ordinary person the highest degree of exasperation, rage, anger, and sudden resentment or terror. The provocation must be of such nature and be so great as to overcome or suspend an ordinary person's exercise of good judgment. And then the killing has to occur just right at that same time. So cooling of the blood, a reasonable time to cool off, is a factor that must be considered if there is an interval between the provocation and the killing. And it doesn't matter how short this is. This can be that person walking to the car to get a weapon. So perfect self-defense, the homicide is either justifiable or excusable. The defendant must be free of fault in causing the confrontation. So thinking back again to the Castle Doctrine, you're at home, you're in bed, your front door gets kicked in, a person wielding a knife comes in, you have a firearm for self-defense, you defend yourself, which results in the death of the other person. It is still a homicide. One person killed another person, but it's going to be, as far as that goes, justifiable under our state law. Depending on where you live, that may be a little bit different. Imperfect, homicide in which the killer subjective but unreasonably believes that his or her conduct was unnecessary or does not meet the requirements of a perfect self-defense. So think back when we covered battered spouse syndrome. That could be something that could be an imperfect self-defense. Justification, excuse. Justification, defendant admits responsibility for killing but maintains that under the circumstances, police power, citizen use of self-defense, what they did was right. So that justification there, again, Castle Doctrine is a great example. An excuse is, by contrast, defendants admit that what they did was wrong, but maintain that under circumstances where they under duress, was a mistake, entrapment, sanity, intoxication, whatever, they were not responsible or less responsible for what they actually did. So justification and excuse, keep those in mind when you start thinking about criminal statutes. Involuntary manslaughter, no intent to kill is necessary, but death occurs because of the unlawful act, sometimes called unintentional or unlawful manslaughter. Involuntary manslaughter is often charged when extreme negligence or wanton or reckless conduct, and we covered that when we looked at Missouri statutes. Again, extreme negligence and failure to act can constitute involuntary manslaughter. So A fires a rifle at what he believes is a deer but hits another hunter. If A's conduct is reckless, involuntary manslaughter can be charged. Vehicular, so death resulting from use of vehicles. Suicide and assisted suicide. Again, I showed you that stat. Suicide is no longer a crime either when successful or attempted. Before this, suicide was a crime. And to punish, if you could look at that as a punishment, the person that committed suicide, they would take their property and then the burial would be less than desirable. So persons who participate in or cause another to commit suicide can be guilty of murder. But the U.S. District Supreme Court held that death with dignity law did not violate federally controlled substance acts. So this is where, depending on what state you live, there are some different laws that a physician could prescribe medication to that terminally ill patient. So assisting suicide, the act of furnishing the means of suicide. In many states, when a person assists another to commit suicide but does not have any direct participation, the crime of assisting suicide is charged rather than murder. And I believe I said something incorrect just a second ago. As far as second-degree murder, I actually meant voluntary manslaughter as far as assisting another in the commission of self-murder. And I've provided this link as far as euthanasia, killing of a terminally sick or injured individual. And you can watch this if you want. It's very interesting about, states that have this law and people that have used this option. So Oregon death with dignity law would be one of those states. The patient has to be found to be terminally ill, so 6 months or less. Mental capacity to understand what's going on. There is a 15-day waiting period after the patient applies and is found to have qualified for a physician-assisted suicide. A physician prescribes drug at the end of the patient's life, but the physician does not administer them. The patient has to actually take them themselves. And the physician is granted immunity from liability for their actions. So, okay, so there's another link right here if you want to watch some more on that. But that is the end of this chapter. Remember to read your chapter, read your blue book, and start looking at that. Again, paying attention to your culpable mental states. And if you have any questions, send me an email and we'll get those resolved.